Contract Act, Section 3, Communication, Acceptance, and Revocation of Proposals. Section 3 of the Indian Contract Act, 1872 lays down the legal rules for the communication of proposals, acceptances, and their revocation, playing a vital role in the formation of valid contracts. It ensures that offers, acceptances, and revocations are effectively communicated through acts or omissions, providing certainty and reducing disputes in contractual dealings. 1. Purpose of Section 3. The primary purpose of Section 3 is to prescribe the legal mode for communicating proposals, acceptances, and revocations between contracting parties. It requires that intention be communicated through an act or omission, as mere undisclosed intention cannot create or terminate contractual obligations. 2. Meaning of communication. Communication is the process of conveying information, intention, or consent from one party to another, and an offer or acceptance has legal effect only when it is brought to the knowledge of the concerned person. Under Section 3, communication may take place through words, actions, conduct, electronic means, or even omissions that effectively convey the party's intention. 3. Communication of a proposal. A proposal is communicated when the person making it performs an act or omission intended to bring the offer to the knowledge of the other party. A proposal may be communicated through a letter, email, business proposal, tender, or oral offer, after which it becomes capable of being accepted under the law. 4. Communication of acceptance. Acceptance is communicated when the person receiving the proposal signifies assent through an act or omission intended to convey acceptance. It may be communicated verbally, in writing, electronically, or by conduct, provided the acceptance is absolute, unconditional, and matches the terms of the proposal. 5. Communication of revocation. Section 3 also governs the communication of revocation, which means the withdrawal of a proposal or acceptance before it becomes legally binding. A revocation must be communicated through an act or omission intended to inform the other party, failing which it has no legal effect. 6. Communication through acts. Section 3 recognizes that communication may be made through positive acts such as letters, emails, text messages, courier, telephone calls, or video conferences. Its broad language also covers modern electronic communication, making proposals, acceptances, and revocations legally valid through recognized digital modes. 7. Communication through omissions. Section 3 also recognizes that communication may occur through omission, where a deliberate failure to act conveys a legal intention. However, mere silence does not amount to acceptance unless the law, established practice, or the conduct of the parties gives it legal effect. 8. Intention behind communication. Section 3 requires that an act or omission must be intended to communicate a proposal, acceptance, or revocation, or must actually have that effect. The law gives importance to effective communication rather than private or undisclosed intention, ensuring that the other party is properly informed. 9. Legal importance of communication. Communication of the offer, acceptance, and any revocation is essential for creating or terminating contractual obligations, ensuring certainty and fairness by making both parties aware of each other's intentions. For more details, contact us.